To race, we are all a bit touchy. When it comes to race, we are all a bit jumpy. I'm not saying whether that is justified or not justified. But now we go back to the question whether or not recognizing the fact that we are all a bit nervy and jumpy when it comes to the issue of race, in Malaysia, do we need a Race Relation Act? Now, let me first tell you my stand before I go on and explain them. I'll try to be brief. First, the position that I take is we do not need a Race Relation Act in Malaysia for a number of reasons. One is a problem-solution mismatch. Because I do not think there is overt racism here in Malaysia. I mean, look at the person who is of a different ethnicity around you. Can you honestly say you hate that person because of their ethnicity? Well, I can't, and I'm sure all of you in this room will agree with me that you can't look at the person next to you of a different ethnicity and honestly say, I hate that person because of his or her ethnicity. So there is really no overt racism here. But I do agree, and as echoed by the speakers before me, that there is an issue with private prejudice. There is an issue with subconscious prejudice. We look at a person of different ethnicity, we give certain labels. We look at a person of different ethnicity, we have certain mindset relating to that person. It's harmless because we do not intend any harm out of that labeling. We do not intend any harm out of our perception of that ethnicity. But it is there. So therefore, that's the first issue. I'm saying that we do not need it because there's a problem and solution mismatch. Private prejudice and subconscious prejudice is not big enough for us to bring into force a Race Relation Act. And I will tell you in a short while why. Secondly, I would say that Race Relation Act would lead to a path where it would be incompatible with human rights. And I will also explain to this in a short while why I say it would be incompatible to human rights. Thirdly, as Shah spoke before me, Race Relation Act as mooted in Malaysia, for now we are not sure whether it's coming into force or whether it will ever be tabled, is mooted to replace the ISA. Now, what kind of law was ISA? Now, having that in mind, how could the mooted RRA be any better for race relations in Malaysia? So there are a lot of questions, but we assume what the government says that it intends to go by the model of the UK model is true, and we analyze it from that aspect, that the RRA model intended by the government to be adopted in Malaysia would be the RRA Amendment 2000 in the UK, and we go by that aspect, and I will still say that it is unnecessary for Malaysia because it is open to abuse. Now, the final reason why I'm opposed to RRA is because it leads to assimilation, or what we call a monoculturalism or nativism, rather than a multicultural society that we have here right now in Malaysia. Now, before I go and explain all this justification, let's just look at the UK example. Because we must understand what we are adopting. The problem with Malaysia is we adopt a lot of things just because. We adopt laws from developed countries just because they are developed countries and just because they have that law. So we think it's pretty dandy and beautiful for us to have similar laws. We do not know the social experience, we do not know the legal background of these countries that justified or brought about those laws in their own country. For this Race Relation Act in UK is a classic example. If really we are saying that we want to adopt the Race Relation Act in the UK, we clearly has not studied the history of racism in the UK. Because since time immemorial, Britain has had this problem with racism. Go back to 1290 when they actually expelled the Jews from the country. Go back to the 16th century when they actually killed the Irish, massacred the Irish. Go back to the Black Moors deportation during the Queen Elizabeth I. Now, it is a country faced with issue of racism, and we are not talking about subconscious subconscious prejudice. We are talking about overt racism, which translate into violent acts, which translate into murders, right? So, faced with those kind of issues, in 1965, the UK government first introduced a Race Relation Act. It is a very limited Race Relation Act. It was basically to regulate access to public places, primarily restaurants and hotels. It is basically to allow people of African origin, of black origin, to be able to access this. But let's not forget, actually that is not a favor that the UK government was doing to the black. Because that is in response, the Race Relation Act in UK has always been in response to either a reactionary measure that the government needed to take arising out of a social unrest, or it's because to mitigate some of the harshness of a law that they have introduced or they are about to introduce. The 1965 RRA was introduced in response to the 1962 Commonwealth Immigrations Act. Now, Commonwealth Immigrations Act, what it did was to stem the migration of Asians from Africa into UK. So in 1962, citing the problem of housing, citing the problem of crime, citing a problem of joblessness, UK decided to stem the entry of Asians from Africa through the Commonwealth Immigration Act. Now, but for those who are already in the UK, and to mitigate the harshness of the law that they introduced to the Commonwealth Immigrants Act, they introduced the RRA of 1965. They realized it was lacking. Social unrest continued. In 1968, they then introduced another RRA. Now this time, the 1968 RRA had two distinguishing features. One, it included provision for housing, employment and services. Meaning you cannot discriminate on the grounds of race in terms of housing, employment and services. It also, the second distinguishing feature is, it also created a board, a race relation board, to govern matters relating to race relation in UK. I'm sorry, there's another distinguishing feature. In 1968, the Race Relation Act requires any act of discrimination to be direct discrimination. Meaning any indirect discrimination cannot be addressed through the 1968 RRA. Both these Race Relation Act was thereafter replaced in 1976. Now the 1976 Race Relation Act in the UK was a bit more holistic because it had to follow closely the Sex Discrimination Act introduced in the UK in 1975. Because the Sex Discrimination Act introduced in the UK in 1975 allowed for prosecution of indirect sexual discrimination. In the similar way, the 1976 Race Relation Act had to allow for indirect discrimination. But again, as I said earlier, this is also a response to a law introduced in 1971. Another immigration law which actually restricted the right of abode. The right of abode, meaning any immigrant that come into UK can only have the right of abode if the parents or the grandparents were already in the UK. So other than that, they can't. So on one hand, they passed the Race Relation Act. On the other hand, they stemmed the entry of immigrants into the country. Now, then what happens? In 1993, Stephen Lawrence was shot. Now, it is a race crime, race-based crime. But unfortunately, the police and institutional investigation into that crime was found to be one thing. There was public outcry, and there was an inquiry, Macpherson inquiry, that was assembled and looked into this, as in particular the way how the police handled the investigation into this murder. Now this is crucial because up to that point, there is no discussion as to institutionalized racism in the UK. But then, after the Macpherson report, the country realized that it is institutionally racist. Now, because of that, they had to respond by introducing the RRA of 2000. And the killers, by the way, the murderers was, I think, only recently convicted. The Stephen Lawrence murderers were only recently convicted because when they were first charged, arising out of shoddy investigation and whatnot, they got off. UK had to amend their law to effect allowing double jeopardy for them to be retried again and convicted recently. But that's a side issue. But now, in the year 2000, for the first time, the RRA Act in the UK recognizes challenge against institutional racism. This is where the problem starts in the UK. Because up to this point, the politicians in the UK and to some extent the society were trying to promote multiculturalism. But having introduced this act in 2000, they realized that multiculturalism is not what they can afford to do in the UK, for reasons best known to them. They were talking about how, by having multiculturalism, people are actually segregated. By promoting multiculturalism, ethnicity doesn't gel with each other, but goes into their own pocket and does their own thing. Now, then there is a shift of the development of the law in the UK, where in 2006 they introduced the first Equality Act, and then thereafter in 2008, Single Equality Duty, and culminating in 2010, as what Shah said, the Equality Act. Now we pause to think. First, if you're looking at the 2000 RRA, as it was amended in the UK in the year 2000, which allowed challenge to institutional racism, could Article 153 be classified as institutional racism? Or any provision, for example, allowing vernacular schools? This is the point where we need to ask ourselves, what is it that we want in this country? Because our constitution has institutionalized provisions relating to various races. Some may be more than the other, that's a given. But the constitution has institutionalized this. So, how do we introduce a Race Relation Act which challenges this kind of institution, which challenges this kind of entrenched position of promotion or discrimination, be it a reverse discrimination of certain races within our society? So that's the first issue that we need to look at. Now, coming back to my position just now, why do I say, therefore, having looked at the UK experience, that there is a problem and solution mismatch? Really, do we want to move towards the path that UK has taken, towards assimilation? That Britishness is more important, or in our case, Malaysianness is more important? Or do we want to keep the multiculturalism that we have here right now? Because I think we all appreciate to be able to speak in our mother tongue, have protection of our vernacular schools, and of course, in terms of Article 153, it's a promotion in terms of socio-economic background. As much as you agree or disagree with it, but that's the intent. Or do we want to move towards the UK position where everybody is equal? Everybody is equal, and everybody is of a similar culture, where we are all the same. So I don't think that would apply in Malaysia. I don't think that is what we want in Malaysia. Now, because that creates another problem. Suddenly, Race Relation Act sought to be introduced to protect various races in Malaysia will now be colorblind. Because we have to admit, being of a certain ethnicity have certain disadvantages. So an equality position that is taken by the government, for example, if it ever happens in Malaysia, I am not holding my breath, but if it does ever happen in Malaysia, will even prohibit reverse discrimination, or positive discrimination, as you call it, right? And rather than having policies which are color conscious, meaning you look at a particular ethnicity, what are the things that they may need, how are they disadvantaged, how can the government help them, it will become a colorblind approach. Everybody is the same. So that I don't think will work. But this is the best part, right? At least in Malaysia, we have political parties along racial lines. But in UK, you don't. So there is inherently already a problem of representation. And that is what in UK they were trying to promote, that minority ethnicity would have better representation in the parliament, better political representation, so that changes can be made. Of course, you may argue here today that, you know, our politicians are by and large useless, and they don't really represent your ethnicity, whatever they may be. But that is something that you can fix. Now, the other issue is, in UK, for example, having had the Race Relations Act since 1958, you see the rise of BNP, British Nationalist Party, where up to 2002 they were having stronger position after the amendment of the RRA. Now, the other position is, we have sufficient laws in Malaysia, and Shah has spoken about this as well, to prosecute any crime relating to race or hate crimes. So do we really need a specific act to regulate in that regard? I don't think so. Now, the other, and one final issue I want to touch is, I do not believe for once that the government can regulate emotions. Because if you really are going to hate the person next to you because of his or her ethnicity, no matter what regulation that the government set forth, nothing will change that. And I cannot tell you, or the government cannot tell you, nobody can tell you how to feel about an issue, how to feel about a person. No one can do that. That is something that only you can decide for yourself. Now, having said that, so long as overt acts that arise out of that hatred, arise out of that emotion can be stemmed, then we say the law is good enough. So there is no necessity for us to come to Race Relations Act. Now, I think I want to touch what the Senator said earlier before I take my seat. It used to be the norm where we promote multiculturalism, but post 9/11, unfortunately, especially in the developed world, most governments are moving away from multiculturalism. They are looking at more of a national identity kind of approach. And I think the good example would be one in the UK and the other one in the Netherlands, where whatever government support there is to promote multiculturalism has been withdrawn. And now they are looking for more national identity to promote. Now, if you are prepared to relinquish your identity in that sense, then by all means, let's have a Race Relations Act here. Thank you very much.
Thank you very much, Faisal. Now I'll go straight to my little bit of cross-examination of these speakers before I turn them over to the audience for you to do your bit of cross-examination. I start with Azmi. Now, Azmi, you said that the government has to justify why we are not treated equally, as opposed to us having to establish why we should. Now, isn't the justification that the government and many parties, one of the justification is Article 1531? And perhaps I'll read it for the audience. 1531 says, "It shall be the responsibility of the Yang di-Pertuan Agong to safeguard the special position of the Malays and natives of any of the states of Sabah and Sarawak and the legitimate interests of other communities in accordance with the provisions of this article." So, what's your comment on that?
My comment is that you can just, throwing Article 153 into our faces and saying, that's it, end of story, it's not good enough. It's simply not good enough to say, oh, our Constitution allows this, and that's it. no more argument, I've done my justification. That is not justification. That is just waving something to my face. Justification requires you to truly explain why certain measures are needed, and on top of that, to justify that those measures are proportionate, that those measures are properly done, and that's very distracting. So it's really a matter of how far you go with your justification. Just telling me that the Constitution allows for certain unequal provisions, and that's all it does. Yeah? All 153 does is give permission to the government in very specific cases to treat people unequally. That's all it does. It's not a right. Okay, you cannot have a right to being treated unequally, to being treated better than others. That's not a right. How can that be a right? All right. So it's just permission. All Article 153 is permission for the government in certain circumstances to act in a way which can be considered as discriminatory. However, for them to do that, they have to justify it on many grounds. All right. First, that they truly have to justify that it's required, and that means not just you telling me, yeah, it's not good enough for Nazri to tell me it's good enough. No, dude, I want more. All right. Okay. I want a lot more. And on top of that, I should have the freedom to debate as to whether your reasons are justified or not. And we don't have that, and that's my point. We don't have that freedom to debate whether your actions are actually justified or not, whether your actions are proportionate or not. We don't have that freedom. And Shah, of course, being the president of the Constitutional Law Committee, would have a lot more faith in the Constitution, and in fact, so do I. Bless them, But so do I. But the problem is that we do not have the necessary aspirations in order to temper the provisions in the Constitution which allow for a different treatment. You see, you need to have an underlying ethos, an underlying ideal that ultimately what is good and what is necessary and what we want is equality. Ultimately. Therefore, everything that you do which goes against that, you temper that. You temper that with this underlying need to treat people equally and fairly. But if you don't have that ethos, then there's nothing to hold you back. There's nothing to temper an activity which, on the face of it, is unequal. I hope you understand what I'm saying. When you do something, you do it only as far as absolutely necessary, because you know that ultimately the ideal is for equality. Right? It's like it's like if you do a surgery, your purpose is to fix the problem. But you don't go cut everything else just because you're cutting, because you know that your ultimate aim is to fix something, and you know that, okay, this is how much I need to do. If I have to take out your appendix, all I do is take out your appendix. I don't go poking around your liver as well. Just because I have the knife doesn't mean that I can go choke your liver, and then chincang your kidney, and then say, oh, by the way, yes, I'm operating, it's the appendix. But you do all these other things as well. If you look at the government action, right? If you look at what's happening, 153 is very, very specific as to what you can do, and a lot of the stuff that they're doing is not under 153. It doesn't fall under what is allowed under 153. So it's already unconstitutional. Okay? But now they've also made laws that says we cannot discuss 153. So everything is shaped for unfairness, and that's what I mean.
Thank you. Shah wants to comment on that as well. Shah?
Testing. Okay. Article 153. Everyone knows this. See, the thing is with Article 153, it's like the federal constitution doesn't matter. What matters is Article 153. Every single time someone talks about Malays or race or whatever, Article 153 will come out. It doesn't matter that all the other rights in the federal constitution may be violated. We must junjung Article 153. let's look at Article 153. I think Dato Ambiga has actually read out Article 153.1. But if you look at Article 153 further, as Azmi has said, there's very specific things which is provided for under Article 153. We must differentiate Article 153 with the new economic policy. There are two different things. One is a constitutional provision, the other is an economic, social, governmental policy. When I hear people say you cannot question the new economic policy, that is wrong. Even Article 153, I mean, you say you cannot question Article, but some people even say you cannot question the new economic policy because it seems to be this sacred thing which we must uphold. But it's not. What are the differences, for example? If I buy a house, I get certain discount because they say I'm Bumiputra. That is not in Article 153. Nowhere does it state in Article 153 that a Bumiputra, a Malay person, or a native of Sabah Sarawak, can obtain discounts when they buy property, for example. No, it's nowhere stated in Article 153. But we keep to this as if this is the most important thing, you know. So we need to make the differentiate. We need to be able to differentiate between the two. And I think this comes back to our education on the provisions of the Federal Constitution, which incidentally the Bar Council through the My Constitution campaign is embarking upon, trying to educate people about constitutional provisions, which Azmi has said. So that's my thoughts on Article 153.
Would you like to comment, Faisal? Do you have a comment?
Very short one, considering how long I took with the speech earlier. I think 153 as an enabler is a constitutional guarantee. We have to respect that. We also have to respect many other constitutional guarantees found in the Constitution. But the point is, I think, in making policy relating to that constitutional guarantee, echoing what the good professor said, whether or not we have had enough discourse, I think that's what we are looking for. Because coming back to the issue of Race Relation Act, before a particular Race Relation Act in the UK was tabled, they had numerous papers, numerous studies before the law is passed. Similarly, any policy that is done, they have numerous studies relating to that. But in Malaysia, we tend to do it just because other people have it. So that's a bit sad in that sense.
Thank you. Now I'm going to go back to 153 again and to Azmi. Now the remaining words of 1531, I said put it to you that it was a justification that they used. Now these words, it shall be the responsibility of the Yang di-Pertuan Agong to safeguard the special position, etc. Now what about these words? And the legitimate interests of other communities in accordance with the provisions of this article. Is that part of 153?
Actually, the whole part 2 of the Constitution is forgotten in this country. So, you know, it doesn't surprise me if things are forgotten. I mean, like, it's not just that. There isn't really a culture of constitutionalism at all. You know, so there isn't you know, we don't. There's so many situations in this country which I would argue is unconstitutional. But we don't have a thriving constitutional law practice in this country where people are taking on issues which they believe are unconstitutional. So, yeah, I mean, we can talk about that, but I think it's bigger than that, you know. And this is my point. Yeah? There is no aspiration towards what the Constitution is supposed to be providing us, which is ultimately a great deal of protection and a fair, just system, and a system with separation of powers, no matter what the blinking court might think. You know, you don't have separation of powers. My foot. I mean, like, you know, I mean, where did you study? Not UM, I hope. You know, so it's a lack of